Hello and welcome to the Micklin Law Group's How-To series. My name is Brad Micklin. I'm the managing member of the Micklin Law Group, which is a law firm concentrated in men's and fathers' rights in divorce, custody, and family law issues. As you may know, I do a daily tip on my YouTube page and I think also on my website, giving you very simple, very brief advice about divorce and family law matters. I also do a monthly webinar series where I put a much lengthier discussion on one broad topic, which also goes onto my YouTube page and my websites. This part is a how-to series. I try to do it on a weekly basis and sort of bridging the gap between the two. The daily tips are very short, very simple, and the webinars are very long and very complex. So sometimes you're looking for something in between. Sometimes there's a very specific issue that you don't need that much information on, like what we're going to cover today. But it's good to have more than just a 50-second tip on it. So today's how-to series, if I forgot to mention it, is how men can pay less alimony. Now let me first say that this will still apply to same-sex relationships. It will still apply to women that may have alimony claims. But in my experience, given the nature of my practice, we deal with more traditional situations, and I see more commonly men are paying alimony than women are. So until that changes, that's sort of the way I address it, but like I said, it still will apply to all types of relationships. So the first way, or the first thing that you should do in order to pay less alimony is read the alimony statute. I don't know if I have any clients who have followed this advice and actually read the statute. There's like, I think 14 different criteria that the court's supposed to look at when determining alimony. If you don't know what they are, you don't know how to prepare for them. You should also make sure that your attorney's read them because, like I said, many of them aren't familiar with it. It had been reformed about 4 or 5 years ago, this video being made in 2018. But the reformed statute didn't really change the majority of the criteria, or at least the basic premises under the alimony statute, so they remain consistent. So you do need to be familiar with that. And you need to then take those criteria and actually start preparing information. You want to get explanations that support or reject the provisions. You want to get documents that evidence why those do or do not apply. You can't just walk in and assume that you're going to have the information necessary to establish the different criteria in your favor. Second is assume that everybody's going to calculate alimony as 1/3 the difference of your income. And I say that because everybody's going to tell you they don't do that. There's case law that says we're not supposed to do that. Judges will tell you that it's not permitted. They're supposed to use the statute and the criteria. But in every single case I had, whenever it's discussed, whether they say it or not, the numbers come out that way. It's 1/3 of the difference. So whether the law says you're not supposed to do it, assume that they're going to. But that's the starting point. So if you want to be arguing that it should be less than 1/3 of the difference, you need to find reasons to support why. That goes back to understanding the statute, because the different criteria will help you eliminate the difference or bridge that gap and make it smaller. Additionally, you want to contemplate changes in your future circumstances, not just yours, but also the person whose support you're paying. You want to look at cost of living adjustments. You want to look at the occupation that they either are in or will be going into and determine, are they likely to get bonuses? Are they likely to get cost of living raises? Are they going to get other raises, performance bonus, stock options, things like that? You really want to contemplate how their circumstances are going to change for their betterment in the future. You also want to consider how your circumstances may change for the worse. Always contemplate if you lose your job. The law is very, very rigid about what it takes to modify support. So you need to contemplate what problems you may incur. You also want to contemplate how your income will change, whether you're going to get the same kind of cost of living adjustments or bonuses or options. That may facilitate your ability to pay more support in the future, for instance, but now starting out paying less to begin with, or even vice versa. But you want to understand where your circumstances are going to go so you know exactly how much money you're going to have. You also want to consider, now that the law is changing, again, this is in 2018, in 2019, alimony on the federal level was no longer deductible. It is on the state level, and it's going to create some confusion in how we prepare alimony numbers, because we're all accustomed to using the net figure, the after-tax income, which usually leaves more money on the table because there's often different tax brackets between the two parties, the paying spouse and the supporting spouse. That's going to be gone on the federal level. You still get a deduction on the state level, so you have to figure out how those monies are going to be affected. And you might want to sort of tax effect the different returns so that you know exactly what kind of net income you're going to have considering both taxes that you might be paying. I would also recommend that you pay very close attention to the case information statement, both in your preparation of yours and in your review of your spouse's. Case information statement is probably the most important document you're ever going to complete in your divorce case. It's a very long, very tedious document that asks you from everything to how much you made and paid in taxes to what you spend a month in hair care. That is generally what judges and lawyers will look to when determining the needs of the spouse, the supported spouse, as well as the ability to pay of the other spouse. Now, part of the new changes indicate that the court's supposed to look at both spouses' past lifestyle. You'll hear terms about comparable lifestyle. Doesn't exist. There's no such thing as a comparable lifestyle when you get divorced. So in my practice, I don't believe that judges have yet to really change that focus, to really start acknowledging that both sides need to have a comparable lifestyle. I think it's going to be some time before the new law catches up to the old judges. So the case information statement is still going to be the most important thing that you're using. You got to make sure it's accurate. You got to make sure that the other one's accurate. Also, what you want to do is you want to build in what may be changing in your expenses in the future. The case information statement is not a static document, although most people complete it like it is. So they'll ask you, for instance, what's your car payment right now? And let's say it's $300. But if your lease is over in 1 year and you think you're going to be getting a more expensive car, or just the general price of cars have gone up because you had a 5-year lease and you're coming to the end and it's 5 years later, things are more expensive, you can put a footnote and indicate that the expense that you have is either going to increase, or even better, put in a higher number, but put a footnote that it's an adjusted number for either cost of living or inflation or anticipated expenses. You may even have new expenses that come up, like child care, aftercare, daycare, college expenses, commuting costs. You can build in these into your case information statement, even though they don't actually exist, so long as you footnote that it's a contemplated change or it's an estimated number. Because case information statement needs to be accurate, but it doesn't need to be exact. So you just need to footnote and explain how you're coming to these numbers. Last, and I may have touched on this briefly, you want to build in reasons for modification. If you're doing this by agreement, that is. If you're going to a judge's decision, which is rare, but it does happen, you're not likely to get in provisions that allow for a simplified modification. I often recommend my clients consider even offering some more alimony in certain areas so that they can get a reduced or an easier modification if and when things change in the future. So although this how-to is about how to pay less alimony, that last tip may actually cause you to pay more short-term, but long-term is going to save you a ton in legal fees and in alimony, because modifying an alimony payment is very, very difficult, if almost next to impossible from a legal and a financial standpoint. So while you may pay a little more alimony to get that provision, long-term you'll be saving yourself a great deal. I hope this information is helpful. For more information on this and other topics, go to my website, which is micklinlawgroup.com. That's MICKLIN, lawgroup.com, all one word. You can call us at 973-562-0100 if you have questions or want to schedule a consultation. Or you can subscribe to my YouTube page, which is Brad Michael Micklin, if you want to get these videos and the other ones that I referenced more often. Thank you.